Today, we're diving into a fundamental conflict playing out in Europe's legal system. It's really a story about technology, tradition, and the very soul of justice itself. It pits France's fierce protection of its judges against a global push to turn legal rulings into predictable data.
So let's start with the big question at the heart of all of this. Should an algorithm be able to predict how a judge is going to rule? Now, this question really exposes two completely opposing views. In one corner, you have the judge as this impersonal mouth of the law, just applying the rules. And in the other, you have the judge as a human being, someone whose biases and behaviors can be measured and, ultimately predicted.
To get our heads around this, here's our roadmap for today. We're going to start with that core philosophical conflict. Then we'll look at France's really unique legal position. After that, we'll contrast it with what's happening in the Anglo-Saxon market, see how the EU is adding pressure, and finally, think about what this all means for the future of justice.
Okay, let's kick things off with that fundamental divide. And you have to understand, this isn't just a debate about some new tech. It's a battle between two legal traditions that go back centuries.
This slide really lays out the two opposing worldviews. The continental tradition, which is huge in France, sees the judge as a neutral instrument for the law. The idea is that justice should be consistent because the law itself is consistent. But then you have the Anglo-Saxon model, especially in the US, which is all about legal realism. It says, hold on a minute, who the judge is, their background, their politics, their biases, that stuff matters. Justice isn't just what's in the law books, it's what judges actually do.
So this philosophical stance led France to build what some have called a digital Maginot Line. It's a powerful legal wall known as Article 33, and it's designed to protect the French judiciary from this new world of data analytics. And what's so wild is how quickly this all happened. It was a complete 180. In 2016, France was all in on transparency, saying all court decisions had to be published as open data. But then startups started using that data, and they showed these huge differences in rulings between judges in the very same court. Well, that sent shockwaves through the entire system, and the reaction was swift. By 2019, France passed a law to ban the whole practice.
What's really stunning is just how severe this law is. Article 33 makes it a criminal offense for literally anyone, a company, a researcher, even a journalist, to use a judge's identity data to analyze or predict their behavior. And the penalty isn't just a slap on the wrist. We're talking up to 5 years in prison. There's nothing else like it in the world.
And France's highest court actually upheld the law. They said it was necessary to stop lawyers from forum shopping, trying to pick judges they think will give them a favorable outcome. They also wanted to stop judges from feeling pressure to just follow the statistical average instead of their own judgment. Now, the law says you can still analyze anonymized data, but in reality, that's almost impossible to do. So the result was this immediate chilling effect that basically froze innovation and forced French tech companies to stop analyzing the human factor and focus only on the legal texts.
Okay, so now let's jump across the pond to a completely different universe. Because in the US and the UK, predicting judges isn't a crime. It's a booming, multi-million-dollar industry.
I mean, just look at some of these companies. Lex Machina gives you win rates for specific judges on specific types of legal motions. Predictive takes it even further. It builds psychological profiles based on a judge's net worth and political leanings, and then claims it can predict rulings with 85% accuracy. And over in the UK, Solomonic is the go-to tool for top law firms who see all this predictability not as a threat but as a serious competitive edge.
This table really just puts it all side by side. The difference is night and day. In France, it's a criminal offense. In the Anglo-Saxon world, it's an industry standard. France is terrified of justice becoming a commodity. The US and UK are terrified of inefficiency. It all comes right back to that fundamental split. Is the judge an institution, or is the judge a person?
But here's where things get even more complicated. France's ban doesn't exist in a vacuum, right? It's part of the European Union, and now it's facing this immense pressure from EU law, which is creating a real regulatory maze. And the key factor here is the EU's new AI Act. Here's the thing. It doesn't ban AI in the justice system. Not at all. Instead, it classifies these tools as high risk, and what that means is they are permitted as long as they follow a bunch of strict rules. This directly legitimizes the very type of technology that France has made illegal.
So this sets up a classic legal showdown that you see all the time in the EU. On one side, you've got the push for a single, harmonized market, the idea that if a tool is legal under EU law, it should be legal everywhere.
But on the other side, you have France arguing for national sovereignty, saying it has the fundamental right to organize its own justice system and shield its judges from market forces.
And believe me, the pressure is only getting more intense. There's a proposed law package for late 2025, the Digital Omnibus, that's designed to make it even easier to train AI models. In this pro-innovation climate being pushed by the EU, France's absolute criminal ban starts to look more and more isolated, maybe even a little anti-European.
This chart really drives the point home. You can see just how much of an outlier France is. I mean, other major European countries like Germany and Italy, they share some of the same concerns, sure, but they're choosing to regulate and debate, not criminalize. And Spain is way closer to the open market model. France is truly standing alone with its absolute ban.
Okay, so where does all of this leave us? In this final section, let's explore the consequences of this clash and what the path forward might actually look like for the future of justice.
And this gets to what is maybe the deepest, most profound fear behind the French law. It's this concept of performative justice. Think about it. If an algorithm predicts a certain outcome, will everyone in the system, the judge, the lawyers, start subconsciously conforming to that prediction? If that happens, the algorithm wouldn't just be describing reality anymore. It would be creating it, basically freezing the evolution of law around a statistical average.
What's really interesting, though, is that the ban has created all these strange, unintended consequences, these paradoxes. For one, foreign companies can still analyze French data from outside the country, which actually puts French lawyers at a disadvantage. It's also forced French tech companies to develop more sophisticated tools that analyze the quality of legal arguments, not just predict wins and losses. But at the end of the day, the ban's long-term survival is under serious threat from all sides.
You know, whether this law actually survives in the long run or not, you can't deny what it represents. Article 33 really stands as this powerful symbol. It's a symbol of resistance against the idea that every part of our society, including the profound act of delivering justice, has to be turned into just another data set to be optimized by an algorithm.
And so in the end, we're left with this massive choice. Will Europe choose the path of the anonymous, institutional judge, protected from the pressures of the market? Or will it embrace the quantified judge, where every decision is just another data point in a predictive model? That, right there, is the question that's going to define what justice looks like in the digital age.